All right, welcome to the Money Market Show. On the show with me today is Yasha Sabba. Okay, Yasha Sabba. He is a chief counsel for Sky Unlimited Law. My goodness, so I'm excited right now. I'll be talking to him before the show, and he just opened my eyes. I've been in real estate since 2005. You know, real estate, you go to school and, real estate class and you hear about law, but you never really practice law. Of course, you're not supposed to practice law, right? You got to leave it to the lawyer. So what you're going to hear today is just going to open your eyes, right? And your mind and all that. And maybe it's going to help your business too. If you're a real estate agent watching this, stay tuned. Don't leave. Okay. And if you're an investor also watching this, you're going to learn a lot of stuff here, and it's going to help you and your heirs, for the long run. So welcome to the show, Yasha.
Thank you, Paul. It's good to be here.
Oh man, I'm excited. Okay, cool. Now let's talk about this. What made you go into estate planning as opposed to immigration law or something, or business law?
I used to be a business lawyer, a patent lawyer, more specifically IP law, helping entrepreneurs, startups kind of just shoot for the stars. That's why Sky Unlimited. We had a lot of entrepreneurs that also were from families of investors. And what had happened was one of my entrepreneur clients, her mom was a real estate investor and had a lot of real estate. And as it turns out, her mom had thought she did an estate plan, but it wasn't a comprehensive plan. The attorney she went to nickel and dimed her. And she thought, okay, if I just build this trust and sign it, everything is taken care of. And unfortunately, that's not how it all works. And fortunately, the attorney didn't teach her enough, but it's not the attorney's fault. The law says it's mom's fault for not having a comprehensive estate plan. And that sucks, I know. Wow. So mom passed away and all of the properties ended up in court, in probate. Probate is in one sentence, it's a court process, a lawsuit you file against yourself on behalf of your creditors, and it's paid for by your estate. All that rental property you have, that's what pays for that court process, right? Wow. Notice family's not in that sentence, right? And what had happened in this particular case, it already sucks that we're in court. Very expensive, very public, takes a long time. But now mom was a very affluent real estate investor, and other family members, her siblings, were coming to court and they were pulling documents out of nowhere. They were saying, oh, mom wrote this will when she came to visited me in another country one day. And she says, all that real estate that's paid off. I know you know the value of paid off real estate, right? All of that real estate that has no mortgage, that all comes to us. The real estate that is underwater, her home was underwater because she was refinancing to take money out and put into these properties. That goes to the two girls, my client and her sister who was in college, no income. Really? So instantly my client had to fire me and I was very bummed. As you know, she was one of my best clients. She was going to be a millionaire in like 10 to 15 years. She had to quit her business, shut it all down and go and get another job that was actually paying her income because her startup wasn't paying her income. Her money was coming from mom and dad. Right. Mom was supporting her. This is a very good family. It's so tragic. And she goes and gets a job at $40,000 a year, first job she can find at a community college. And she's now paying for herself and her sister and that underwater property that has mortgage, and as it turns out, the probate, with all the fighting with the family, caused a lot of conflict. It took about 18 months. We had a probate in Nevada because mom had some real estate in Nevada. We had a probate in California because mom had real estate in California. And it costed over $280,000. Wow. We had to sell some of the properties in Nevada just to pay that bill. And then now daughter is left with a worse career. She's now at about 100,000. She's still at that job. Her career is pretty much set. She's in the nonprofit community space. I'm not saying it's a bad job, but if you guys can imagine you're going to make $1 million one day. You're a star child. And all of a sudden, because of a family tragedy, your life turns over. Right? And now the real estate portfolio is less. Our family relations with the other family members are worse. And so these girls are going to do just fine. They are rebuilding what they learned from mom in investing, which is good, but their lives have been turned upside down. not only the loss of a parent, which is incredibly hard,
Right.
but also just the hoopla of the law, family conflict, and all of that. So when we build an estate plan, the goal is to keep your family out of court and out of conflict. A lot of people, especially real estate investors, foolishly, in my opinion, make only wills and they think that their family is protected. And Paul, as you were learning from me earlier today, all wills go to court.
Right.
Because only a judge can authenticate a will. Only a judge has the right to say, this is truly your will, right? So that's fine. That's not a problem. But the fact that it goes to court costs money. Court is public. Court takes time. They don't care about your family's time. They care about court time. In California alone, a probate process is a minimum of 8 to 12 months. And the rule of thumb that I give to real estate investors is take the fair market value of your home. I don't care about your equity, because when your home goes to court, we only take the fair market value of your home. And we say that value belongs to your estate, even if it's not. If it's all owned by the bank and you have just a little bit of equity, it does not matter. Welcome to California law. And from there, 5% of that. So if you have a median price of a home right now in California is 1.2 million.
Right.
If you have a $1.2 million home and that goes into probate, 5% of 1.2 million, that is going to be the cost of your probate. And I have to use a calculator because I'm a lawyer. That's $60,000.
Right.
$60,000. Where's that money coming from? How are you going to pay the lawyer fees, the executor fees, the court fees? Right. If you don't have that $60,000 in cash in a savings account, which most real estate investors I know don't, because it's so capital intensive investment, then the property is getting sold. And at that point, all that effort, everything, all the hurdles you jump through, the underwriting, the credit checks, the finding of the property, paying the commissions, all of that wasted because now the property is being sold and you are not enabling your family to inherit property from you the right way. If you want to avoid probate, there's two things you can do. One's really cheap, but not comprehensive. And one is very comprehensive. The cheap thing to do is just file a transfer on death deed on your home. California has legalized this temporarily. We're still kind of seeing if we like this law, but it'll last over the next 5 to 10 years. So you just record a transfer on death deed on your home. It's like naming a beneficiary for your property. Nice and easy. There are downsides to that though. Downside is there's no contingency plan. What if your beneficiary passes away? Or what if you're a joint owner? If you file a beneficiary designation, but the other individual doesn't, when you pass away, it doesn't go to your beneficiary, it goes to the other co-tenant, you know? So small nuances like that create what we call risk. And if you're an investor, this is what you're looking at all the time in investment: risk, and lowering that risk to make your investment more secure. So what's one way to guarantee security? A trust. People have heard this before. The problem is people think trusts are like will substitutes. However, they're a little bit harder to set up. There's a little bit more of a dance. You can't just sign the document and say it's done, right? You got to build the trust, and that becomes an empty shopping cart. And then you got to move your assets, all your properties into the trust. We have to retitle the home to the trust in order to have the home avoid probate. And as simple as that, a trust takes no more than 6 weeks to administer once you pass away. And then on top of that, we can build contingency plans. If I'm in the car and my beneficiary is my children, they're in the car with me and we all get T-boned at an intersection, shit happens, so to speak, then who should inherit that property next? Should it go to your other family members? Do you want it going to charity? Do you want it going to your best friends? You get to decide. At that point, the question also becomes, do you want your children inheriting these properties outright? Or can we build lifetime asset protection so that all of the inheritance, including all of your investments that you are giving to your loved ones, will have a firewall, a legal shield between the inheritance and their life sticky situations, their lawsuits, their divorce, their creditors, their bankruptcy. We might say here in California, we don't care about that. Inheritance is considered separate property. My little angels will inherit all of my real estate and it'll be their separate property. Well, guess what? We're now in an era where Americans are moving around a lot more and they are going and taking jobs in different states. We have people that their families here, their investments are here, but they're moving out to Miami. They're moving out to New York. Those are states where you don't have community property, you know? And if you're married and you live in those places, those places have laws where your surviving spouse can stake a claim on all of your separate property in addition to your marital property. So you as a parent putting in this investment, wanting your children to inherit the empire and wanting that empire to keep a roof over their heads and money flowing no matter what. So that way they don't have to worry about money ever again. Imagine your child never having to go through underwriting for a down payment on a home, for college tuition, for a car, because they have enough income from this real estate empire that you have built for them. That's huge.
Right.
Huge. So why would you risk the fact that they could move at any time? And the moment they leave California, they lose that separate property protection. A trust is the simplest tool that can protect from all of that. The hard part is there's not enough education around this.
So you mentioned how you got into this, and you mentioned all other ways to protect your asset. I got so many follow-up questions.
Sure.
This one is basically, what is the worst scenario you've ever encountered in your law practice where somebody did not protect their assets, using a trust?
As I mentioned earlier, one of the worst scenarios was that client that had about 50 properties, 50 doors, 50 doors. Okay. Yes. We're talking about $100 million worth of real estate. Yes. Okay. Now he came from nothing, rags to riches, and came into this country, worked his butt off. Okay. And what ended up happening was he was getting into the real estate game. And as you know, once you're an investor in one property and then you go to two, then you're like, okay, not so hard. You start building your systems, you start building your processes. This guy had it down. He was doing wholesaling. He was doing direct buys. He had multifamilies. He was involved in commercial real estate. He had a great portfolio. Right. And this portfolio was making substantial sums of money, over $1 million of income a year. His problem though, was some of it was in LLCs. Some of it was in his name. He had no estate plan. Right. And he thought, okay, I'm going to put the property in LLCs. That's going to protect me from the property. We call that inside liability. Right. He did not protect his properties from his own life circumstances. We call that outside liability. Right. And from that, he passed away. Unfortunately, he had a heart attack working his butt off. And all those properties, those LLCs, they were all in his name personally. He had no estate plan, right? He didn't even have a will, which I find that very amazing. Having so much net worth, he never, I was questioning the family. I was like, this is very strange. And I thought it was almost foul play at first, because I was like, there's no way someone has 50 doors, $100 million worth of assets, and they don't even have a will. Right. You will have enough professional advisors, tax advisors, bankers, mortgage brokers, real estate agents telling you, hey man, you're rich as fuck. You need to go and set up an estate plan. He didn't trust anybody, as it turns out. That was what the family told me, because from rags to riches and where he came from his heritage, he just could not trust anybody. He was too scared. I get that. But unfortunately, even though he didn't trust anybody, he didn't take the time to educate himself about the law and about how to protect himself. And he had a very good tax advisor. I talked to the tax advisor and he said he wouldn't even let me talk about this stuff with him. Otherwise, I'd lose my business with him. He said, don't even go there, just do my taxes. So this guy was a really tough businessman, which is okay. There's nothing wrong with that. But all of that went into probate. 5% of $100 million. You do the math. That is how much it all costed. Now, our fees were not, I didn't make millions off of that. That's when the judge comes in and says, okay, this is stupid. We're not going to make a ton of money for nothing. So the judge lowers that amount, but it was a few $1 million that he owed. And then the worst part, he was too rich. The government says you have too much money. So he had a net worth from that $100 million of real estate. Obviously, a good amount of that is leveraged. So the government says, okay, let's ignore that amount. He probably had a net worth of about 50 to 60 million. Right? Now, the IRS in this country, there's something called a death tax, an estate tax. I call it the death tax. It's an estate tax. California doesn't have this. New York, Florida, they do. Florida doesn't have this. New York does. I'm sorry, I misspoke. But the federal government, the United States, Uncle Sam has this. And they say, if you are an individual, you have an exemption from the estate tax. Today, it's up to $12.6 million, the highest this exemption has ever been. Thank you, President Trump. In a few years, it'll come back down to President Obama's number, which is about 8 million, unless President Biden does something different. If you're married, we can work to combine it with estate planning. So he was married, but we couldn't combine because he didn't build an estate plan. Right. So he had an exemption of 12 million, roughly. And this was actually a few years ago. The estate tax was a little bit lower. It was about 8 million at that time. Right. And anything above that amount, the government wants to tax at 40%, one of the highest taxes we have in this country. Right. So if you are building your wealth and if you see your real estate appreciating, and if your net worth, and my recommendation is take the fair market value, because right now you say, I don't have that much equity. In the future, you might pay off that equity and all of a sudden your net worth doubles. So just take the fair market value. Let's look at that and let's look at how much it is. And if it's over 12 million, you have a serious tax problem that the moment you pass away, your family is dealing with this. We had to sell a quarter of the portfolio just to pay the IRS back. That money did not go to the family. All that hard work, all that struggle he went through of building that empire, gone with the wind. He basically built it for the government. It was the government savings account. That's where I get so upset. I don't want to be upset at him, but a little bit, I feel he was too stubborn to listen to professionals that were telling him, you have a problem you need to deal with. Anyone that owns real estate in California or anyone that has a minor child, these are the two variables that make estate planning critical, because the aftermath can be so expensive and detrimental and traumatic to your family. So the best thing you can do is build an estate plan, whether that's a will, whether that's a trust, you get to decide, but then we can figure it out.
So I understand having an estate plan is a great thing for anyone who's building any wealth, unless you want to rely on Social Security. So for anybody who's really, it has a portfolio, somebody has
anyone with a portfolio, absolutely.
Business, or they have real estate, they should have an estate plan, right? Yeah. So let me ask you this. What's the percentage of people that have estate plans?
There was a number where we said it wasn't me. I think it was the Association of Counsel for Estates and Trusts. I think I butchered their name. There might be called something else, but there was an association, and this was about 5 years back, and they said about 50% of Americans have an estate plan. Okay, so
is that high or low?
Legally, everyone has an estate plan. The government has a plan for you. Don't worry. You have an estate plan. But if you rely on the government, when the government comes in saying, we're here to help, do you trust that? No. The government's estate plan for you is designed to protect your creditors. The reason for this is because of one thing. In this country, we do not allow your debt to be inherited by your family members. In medieval times, when there were kings and queens and the United Kingdom was all split up, you had landlords, or what we call lairds. That's where the landlord concept came from. And it was the landowners, and the people were working on the land, and they would owe money to the landlords. And if they didn't pay that money, they'd owe a debt. And back then, if you had died, which back then the average lifespan was about 40 years. When you died, if you didn't fully pay your debt back, your family would inherit that debt. And this is how we ended up in a situation where a bunch of children became wards of these landlords, not necessarily adopted, but the landlords, they were indentured to them to pay off their family debt. It got so bad where you had family members scared of debt, so terrified of it that when uncle was building up a gambling debt, the family would go and kill uncle to say, you're going to put us in trouble with all of these loan sharks or stuff like that, So in came Parliament that said, okay, no more. We're no longer going to let people inherit debt. And we translated that here in America, which is great. But as you know, Paul, firsthand, we are a country built off of leverage. That is our power, the ability to use leverage to amplify our investments and our growth. And because of that, we need creditors to be willing, banks to be willing to give people loans. And if it turns out that you could die and that loan is gone and the bank can't go and reclaim that money, do you think a bank has the economic incentive to give a loan? No. So that's why we have the probate process. When you die, it's allowing the bank to stake a claim against your assets so that they can get their debt paid back. So probate is about protecting creditors, not your family. If you want to avoid probate, you can build a trust or you can put beneficiary designations on all your assets. That doesn't mean you can avoid creditors, but there's an advantage here. Welcome to the legal world now. Your will goes to court and we have to tell the court a whole inventory of everything you own. Your trust can hold all your assets. It's a private document. Even if creditors are in court trying to claim their debt back, we don't disclose the assets inside the trust. So the court and the creditors don't truly know exactly how much money you have. This gives us leverage to negotiate with the creditors saying, oh, there's a lot of creditors. There's not that much money. Instead of paying the full amount, we're going to pay a fraction of the amount and you can write the rest off. Do you accept or no? And we tell them, if you don't accept, then you are going to have to go to trial, which is even more expensive and time consuming to everybody. And you're going to have to justify your debt because we're not going to accept it. We have a right to reject it, right? And credit card debt, very hard to combat with, but loans, private loans, hard money loans, oh yeah, much easier to combat those.
So you have these assets. You have 5 properties, and you put these 5 properties in a trust. So now, okay, what happens when you die? So what happens to the money that you owe? I mean, I'm just trying to understand what you're saying here.
Sure. So practically speaking, what would happen? Your trust is like a will substitute. You've named someone to be in charge.
Right.
Everything goes as normal. The properties are making their income. Now someone's in charge, making sure that the properties are being managed.
Right.
And let's say you've got a $25,000 credit card bill, right? Now we're not opening a probate. We don't have to because you have a trust. So anyone can open a probate. It's not just family that can open that court process up. If the credit card company wants to go after the properties or any assets, if they know that, okay, these properties are owned by you because you may have disclosed it or somehow they figure things out, then they can go open up the probate and pay the money to do it. They'll give notice to the family and then they'll say, Judge, we know that this person that died has 5 properties in a trust. So if they know that, that's to their advantage. And then the judge will say, okay, you need to work with us on paying off these credit card bills, right? And that's what we would do. Usually the trustee would take the cash in the trust and pay off the debt. You can't hide from the debt, right? That's not what this trust is designed to do. But if there's another creditor that comes in and they don't know that these 5 properties exist, that you had owned these 5 properties because you did a good job taking your name off the properties, putting them in LLCs, putting them in land trusts or something. This is how we can create a layer of privacy for you if you care about that stuff. Then we have more leverage saying, okay, how much do we owe? Oh, $50,000. Okay, we only have, let's say we have $10 million in the trust. We can say we have $10,000 that we're willing to pay on this loan. Take it or leave it because there's nothing in the probate. And they'll say, okay, because they don't want to go to court. It's kind of the business of the expense of court and litigation. Lenders don't want to go through all that. They just want to lend their money out and make their interest, So you get the advantage by having that trust. Now, if you don't have any creditors, by having the trust, you avoid court. It's all private. If you say, give the homes to my children, we can have that done in 6 weeks. Or if you say, leave it in the trust for my children, we can use the trust as a tool to shield the properties in the trust from their lawsuit, their creditors, their divorce, their bankruptcies. Their life circumstances will not affect their inheritance because of that shield. That's an option too.
Okay, so wow, that's interesting. So let's say a lot of people use LLCs. And in California, for example, I mean, anybody can go to the website, to the state's website and find out who owns that LLC.
Yeah.
You're saying that the ultimate way to protect your assets is actually have a trust. And in that trust, you don't need to reveal to anybody what that trust owns. And so therefore, if somebody wants to go after your assets, somebody sues you, okay, then you're protected and they can't go after the properties that you have in that trust. Is that correct?
No, your trust isn't going to protect you from a lawsuit. There are certain types of trusts outside of California, like in Nevada, where you can set them up and they can protect you from a lawsuit. But if you're holding real estate, no, it's not going to work. It's only if you have liquid cash. You could put some cash in a trust in Nevada, like a savings account, and it can be protected from your own creditors and your own lawsuits. But when you own assets, when you put them in a trust, that trust is more of a see-through entity. It's an abstraction layer. You still own it. They are still beholden to your creditors no matter what, right? Mm-hmm. But the question is, if you've dealt with creditors before, anytime a creditor is coming after you, it's a negotiation. It's not you owe $50,000 and either you pay up $50,000 or not. It's hey, I don't have $50,000. What if I give you $5,000? Will you accept that and walk away? Mm-hmm. And a lot of times these creditors, they are reasoning with themselves. What's the opportunity cost here? How much time and legal expense am I going to pay pursuing this $50,000? I might lose money out of this. It might end up costing $100,000 just to get that $50,000 because of the legal battle, right? So that's where you have leverage in negotiation. A trust won't protect from that. A trust more is that privacy concept is just giving you leverage of negotiation in probate. It also helps your assets avoid probate. Rule of thumb, the cost of assets going through probate, 5%. You just save 5% by using a trust, right? Now, if you want to really protect your privacy, your LLCs, I put my property in LLCs. The question is, who owns the LLC? If you own it, that LLC and everything in it is going to probate. Right. If the LLC is owned by the trust, it avoids probate. So that's the first step of estate planning. Let's avoid court and avoid conflict. Right. After that, if you have creditors, then it's a factor of how do the creditors figure out what you own? We can look at property records. We could see it's owned by the LLC. We could go to the website of the Secretary of State, see who is the manager of the LLC. Right. You don't necessarily know exactly who the owners of the LLC are. That's still not public, even in California. But from there, you can go after the LLC itself because the LLC is a person, right? If I don't own, if the creditors aren't securing the property, like on a mortgage, if it's just a personal loan that was given to me, how will they know that I own that property when it's owned by an LLC? How will they know that I actually own that LLC? That'll actually be very hard to do unless what most investors are doing is they set up the LLCs. They put the business address of the LLC as their home address. They put themselves as the manager. And now I can tell easily, like, okay, you did this all self DIY. It's all yours. If you don't want that, if you want privacy, if you want your name off the deed, off the corporate records, there's a combination of LLCs and trusts that you can use. For example, very simple. I want to buy a house, this house that I'm living in, but I don't want my name on the deed. I don't want my name on the property records because I don't want anyone knowing that I own this house. So what would I do? I can either set up an LLC and hire someone else to be the manager, and their names are on the business documents. Downside with that is I have to pay that franchise tax every year, $800 a year for my own residence. That sucks, you know? Or I can set up what we call a land trust or a nominee trust, a special type of trust, very simple, where when you are buying the property in escrow, you're saying, give it to my lawyer, trustee of this trust. So then the lawyer's name is on the property records. The trust document is private. You are the beneficiary of the trust. You're the owner. You can revoke it. You can change it. You can hire and fire the trustee anytime you want. So you're still in control. But on the deed, it says my name instead of your name, trustee of this trust. And the trust won't even have your name. We'll make the trust 123 Baxter Street, the property address, you know? And then once we do that, I can resign. I can resign as trustee and make you the trustee. Do we have to update the deed? No, we don't have to update the property records until you're ready to sell the home. This is what we're doing for a lot of our clients, high net worth clients, celebrities, that they want to maintain their privacy, but they want to keep it cheap and affordable. There's no cost of maintaining a trust when you're the trustee. As long as there's no income, you don't have to file a tax return. And the way this trust is designed, you'll never file a tax return while you're alive because it's a see-through entity for the IRS for any income and losses. So as you can see, the reason why people aren't doing this, because it sounds complicated. There's a lot of variables to it. But if you hire a professional advisor who's good enough to break it down to you and help educate you, then It's not that hard at all. And it can actually be affordable to do in the long run. And you get the benefit of your privacy, and the trust can say, if something happens to you, who are the beneficiaries down the line, or we can have it funnel into your estate plan trust, your revocable trust for everything else, your bank accounts and all that stuff. You know, you can have as many trusts as you want.
Right.
The analogy I give everyone is, think of estate planning as your estate is a grocery store, and all the items on the shelves are your assets. Mm-hmm. And when you build a trust, you're merely building a shopping cart and pushing that into the grocery store. Mm-hmm. The person who's the trustee, which will be you during your lifetime, you're pushing that shopping cart, and obviously it's an empty cart. We got to transfer your assets into it. Mm-hmm. Anything in the shopping cart can walk right out of that grocery store. Everything else has to go through the checkout line, and that is probate, and the cashier is the judge. That's the best way to think of this.
Okay, that's great. All right, let's talk about small business owners, for example, and let's say you've been talking about real estate primarily. So let's say, how do you protect, of course, a business that you own is also an asset, maybe actually the biggest asset, Yeah. So how do you protect that? You also put your business on trust, or what do you do?
Small business owners are actually the most vulnerable people.
Yes.
Because they don't realize that all of their value in life is actually tied up in their business.
Right.
And most of the time they're running the business focused on income and revenue, that they don't realize what they're building, the processes, the clientele, the assets of the business is increasing in value over time, their brand. And so if you don't protect that, having a business go into probate can be a very damaging and expensive situation. Either your business is very well built and very expensive, so that's where the creditors say, let's sell the business, or your business is not well built at all, but you would hope that maybe your kids or family would take it over. The problem, though, is now your business is in your name, not your kids or your family's name, and it's now in probate, and the creditors say, this isn't a good business. I can't sell this easily to another person. Let's ask the judge to liquidate the entire business, and the entire business just gets dissolved overnight. Either that, or the family has to pull money out of their own pocket to pay the creditors back. This is when people feel like they are responsible for their deceased loved one's debt. They're not responsible to pay that credit back, but because the business belongs to that loved one, it is responsible of paying the creditors back. And if it can't, it gets dissolved. And all the assets inside. So you're a business owner. If you have an S Corp, an LLC, a C Corp, whatever, those are business entities that you own. It's about your ownership that we care about, not the assets inside the business. We don't care about that. Run your business how you want to. It's about your ownership of the business. We need to put that into the trust. Mm-hmm. And once it's in the trust, it can avoid probate. We have more leverage and flexibility to move money around to deal with the creditors. Mm-hmm. And then we have more leverage to negotiate with the creditors because they don't know the value of the trust because that's private.
Your advice is anyone that's listening out here watching this show, and so long as they have assets, whether that's real estate, precious metals, or cryptocurrency, or a business, they must actually have a trust. Otherwise, it's jeopardizing the asset. Is that correct?
Arguably, yes, a trust is stronger. I don't like to tell people you must have a trust. I don't like to tell people what to do. Yes. My job is to educate you, make you realize on what is at stake and what are the risks. Mm-hmm. In business, it's all about risk, right? Mm-hmm. And sometimes the risk can be high, but we're willing to accept it in order to receive a better return, right? Real estate investors know this a lot. So if you're okay with the risk, you don't have to have a trust. You can have a will. I have a client, $20 million of assets, bank accounts, real estate, what have you. He has a will. It's a little sadistic, but it's his way of teaching his kids financial literacy. He wants them to go through probate. Okay. And every few years we review his estate plan together. And I say, do you still hate your children? So to each their own. I will do whatever my clients want me to do, as long as I know that they are 100% aware of the law and how this all works. I know that you will make better decisions for yourself and your family. And by giving you that empowerment, it makes you a little bit more financially literate. So what I would say to the world is, if you are looking for help, if you're looking for advice or counsel from an attorney, on your estate plan, on what's the right way of protecting your business, what's the right way of protecting your investments, keeping your loved ones out of court, out of conflict, right? You want to find someone who's going to educate you. If they're not willing to educate you, don't go to them. They're going to tell you what to do, and you'll never know if you're doing the right thing. And that's where this gets dangerous. Is I see failed estate plans all the time because people thought that they were getting something. And then I read their legal documentation. I was like, nope, that's not what you did at all. Right? Because maybe they were miseducated. Maybe they were enticed to do a certain design or a certain plan where they were splitting up the assets or doing some crazy stuff. I like to say, keep it simple. The only time we want to go complex is if there are questions where we educate you on what those options are and why you would consider going complex, you know? And that's the way that I teach attorneys. I teach about 400 attorneys around the United States how to do the estate planning. Okay. We call ourselves personal family lawyers. You can find us on personalfamilylawyer.com. Okay. And from there, we all believe the traditional model of law is kind of failed and that the incentives aren't designed right, where it allows our clients to be proactive with us. And it also allows where the attorneys are educating the client rather than telling them what to do. So when you say to me, Yasha, so the ultimate way to protect everything is building a trust, I will say, yes, a trust is an amazing tool, very flexible, can be constructed in so many ways that can give some pretty stellar protections. If you want to be an investor and you want to level up, you want to grow your wealth, you are going to enter the trust world. All high net worth individuals, that's what they deal with. That's how we keep things private and we don't put anything into the public eye. But if you have different ideas, have different thoughts, want to keep things simple, maybe create a will and only put some things in a trust, but not everything, we can do that too. This is where I care more about my clients and making sure that their estate plan, not just legal documents, but their plan meets their life needs, goals, and objectives. And that's what a true personal family lawyer does for you compared to traditional lawyers that you see every day.
So you guys are called family lawyers as opposed to estate lawyers?
We're not family lawyers. This is, I know there's like a difference. Family lawyers, divorce, guardianship, that kind of stuff. Estate lawyers, wills, trusts, and long-term care planning, high net worth planning, and just asset protection planning. We are branding ourselves as personal family lawyers because we want you to think of us as that legal support in your back pocket. I got a guy that I can call. You know, anytime you hear some stuff, you hear some bullshit from other friends, you guys are having a barbecue and they're talking about investments in the law and you're like, that doesn't sound right. You can call up your personal family lawyer. Most of us, we don't charge by the hour. I don't charge by the hour. Everything I do is either flat fee or subscription based because I want you to call me. I want to educate you so that you are more aware of the law and how to protect your loved ones and assets. This makes you a stronger entrepreneur and investor. This is what we do at Sky Unlimited Law, making our clients stronger investors so that they can move faster and they can make better decisions in their investments down the road.
So you said a subscription basis. What is that? How does that look like? So
most of the work we do is on a flat fee basis. We tell you upfront how much it costs to build your trust or this or that. But there are some clients, our VIPs, that want a little bit more service and help from us. So we've created a membership program where they can join. And that allows them to have ongoing service where we meet once a year. We're maintaining their asset inventory for them, stuff like that.
Frozen here.
Of our high net worth clients, they would like us to act as loved ones. And then from there, that's when we can go on the subscription and make it a cheaper option for their loved ones by doing it. So there's like a little bit of a cost benefit analysis. If you want more work from us, instead of us nickel and diming you and making it too expensive, let's get on some kind of recurring fee basis. That way it makes sense for us to be able to offer you that additional support and help. And then it keeps costs low and flowing for you.
Well, so there's a lot to digest today. The last thing I want to ask is basically, let's talk about the gift of equity here. So we'll talk about like somebody, there's a parent, wants to sell property to the son, right? And basically the son doesn't have any money, right? And then of course, so uses that equity, as a down payment. So yeah, since you are the guy who specializes in this kind of stuff, assets, and protection for the family forever, right?
Yep.
I'll talk about that.
So you have a child that wants to buy a family home, and the family wants to sell it to him, but he doesn't have money. So the family's saying, we're gonna give you a break. Instead of selling this home to you at fair market value, let's say the home's worth is 1.2 million, median price in California. We want to let you have 200,000 as a down payment, and you just pay us back $1 million. Okay. The IRS has a problem with that. The IRS says, you need to pay taxes if you're going to sell the home, even if it's to another family member. When you transfer a home, it's either a gift or a sale, nothing else. So the IRS says, okay, that $1 million is the sale. You're going to pay capital gains tax on that, whatever your basis, whatever you originally bought, whatever you invested in the home, and then any appreciation of there, like you know, Paul. And from there, the other 200,000, that wasn't part of the sale, because the sale, the $1 million, was under market value. The remaining at fair market value, we're counting that as a gift. So a lot of family members, this is what they do. They don't think about the gift of equity. They think, oh, the house is 1.2 million. I'll sell it to you for $1 million. And the IRS says, no, you can't do that. You cannot skirt the fact that this home fair market value is 1.2 million. So when you do the sale, get an appraisal around the time of the sale, so you can have an argument against the IRS on what the true value is, because they will come up with their own appraisal. And remember, the IRS has an economic incentive to tax you. They want money. This government, the United States, Uncle Sam, is desperate for money today. We just lost trillions of dollars because of COVID, all money in our pockets, stimulated. We feel good, but now we're hiring 40,000 new IRS agents over the next 2 years. Oh yeah, everyone's getting audited now, because they want to collect that money back. So if the fair market value, you get the appraisal, it's 1.2, you sell it for $1 million, then you're gifting the other 200,000. Now, in gifting, there's no tax consequences per se right then and there. Here's the rules. Every year, you can gift $16,000 per person per year. So if you have 2 kids, you can give 16 to one child, 16 to another child. We don't bat an eye. The IRS doesn't care. You don't even disclose it. We don't care. $16,000 per person per year. We call that the gift tax exclusion. It's excluded. We don't care about it. Anything above that amount will fall under the gift tax. And during your lifetime, you have an exemption. Today, the exemption is about $12.6 million per person, right? That is the estate tax, like what I was talking about before. It combines the estate tax, gift tax exemption, lifetime exemption. So if we had $200,000 and you sold that home to the son for $1 million, that $200,000 was a gift, we would subtract $16,000 because that's excluded. That leaves $184,000. Right. That amount you would have to report to the IRS for that tax year as a gift. And the IRS is keeping a tally of how many gifts you are giving out, how much money you give out as a gift during your lifetime, right? And as long as you have not eaten up your exemption amount, there's no tax. So for the most part, most people, most parents gifting property or interest in property or equity to their children, they're not going to pay a gift tax. But
that to the children, or can that be another relative, or can that be
anybody? You can gift to anybody, and that's there's the $16,000 exclusion per person per year. So now imagine if mom and dad own the home and they want to sell that home and they jointly own it to their child, that's $16,000 per parent to the child. So that's another $32,000 total excluded. And then the remainder is a gift, half from mom, half from dad. And those gifts are using up their estate tax exemption. So this is what we usually say. If the house is in dad's name, for instance, bought as real estate, whatever, we would say before you sell the home to your child, let's add your spouse onto the home. So let's add them to the title and let's wait a bit in time, usually about 6 months to a year. And then in 6 months to a year, let's have both of you transfer that home to that child. And that's how we can lower the amount of the gift, spread that gift between both spouses, because every person gets that $12 million exemption. Now, $12 million sounds like a lot of money. And everyone says, Yasha, why are you talking about this? We don't care. We're just going to gift it now because I'll never have $12 million. Okay, I hear you. That's a political number. That number goes up and down with almost every presidential cycle. During President Obama, that number was 6 million. President Trump came up and he doubled it to 12 million. Congress didn't allow President Trump to make it permanent, so they set it to sunset. That 12 million number, the exemption, will come down to about 8 million in 2026. And President Biden has been trying to bring it down even more. He hasn't won yet, but yet, remember, he's still president and he can keep trying as long as Congress is ready. And the more hungry for money the government is, the more that exemption will come down and more people will have to pay these taxes. You know?
Okay, let's say I'm an employer and my agent or my employee wants to buy one of my properties.
Okay.
So could I gift this person equity in my property?
Yes, of course. And then whatever that amount of that gift is, $16,000 excluded, right? And then the remainder, you have to report to the IRS so they can tally up how much you're gifting over your lifetime.
Oh, okay, interesting. So that has to be done before the sale, at the sale of the property. I have to declare this is a gift, not after.
It can be done after. It's obviously not before the sale. When the property closes, that's when the gift is formalized because you've either given them the property at under market value or you just transfer the property to them. It's not even a sale, you know? And when that happens, you report that to the IRS with your tax return. So we all file a 1040. That's our income tax return. You're going to file an additional form called your estate tax return, which is where you report your gifts that you make.
Wow, that's amazing. Okay, obviously I've learned a lot today. So a lot of people are out there and they don't have a trust. And some of them don't even have an LLC, right?
Oh yeah, tons.
I have access to 53 million properties out there. You know, some of them are in the LLC or in the corporation, but a lot of them are also owned by private people in their private names. Maybe for some ego, they want to keep it in their private name. You know, so
it's a little bit of ego. It's a little bit of they're too cheap. They don't want to hire. They don't want to pay a few $1,000s for a trust. I get it. I really do. But right once that property goes to probate, I'm making more money off of it. So I'm okay with it. Put them all on your names. I'll take your family to probate and we'll make a ton of money, you know? More money, more problems, right? This is how I get paid. So this is where...
So my advice here, if you're a real estate agent and you're dealing with investors or not even investors, people, homeowners, right? And they have a ton of equity in their homes, you know, I mean, my advice is basically they have to look into, or they should look into creating a trust. And if you're an investor watching this, by all means, please look into creating a trust because that will keep you and your family, especially your family, you know, out of probate. Even if you have a will, as you heard Yasha say today, if you have a will, it's going to go to probate. And the court, you don't want Uncle Sam and the court system deciding what should happen to your assets after you are gone, you know, or even while you're still alive, I guess. Okay, so Yasha, is there any other thing that would like to share with us today? I mean, imagine there's a world out there and people are going to be watching this video and all that stuff on LinkedIn and YouTube and other places, right? So is there any other thing that I'm missing? Just
a little caveat, disclaimer. I'm only licensed in California and the laws of every state of the United States are very different. It's not all the same. If you are looking for an attorney to help have a conversation about this, I do recommend you go to personalfamilylawyer.com or you can reach out to me. Paul has my info. Reach out to Paul, say great show, subscribe on YouTube, and then reach out to him to reach out to me. For Californians, as long as you guys drop Paul LeJoy's name, I will give you guys a free family wealth planning session. This is $750 credit. You just let me know that you're coming from Paul. It's my courtesy that I give to all professional advisors such as Paul, where we will take what you guys are learning here and make a snapshot of your state. And I will show you how the dominoes will fall if you don't survive that meeting. It's a nice, fun game we play. From there, we can tell you your options, and then you can decide if you want to move forward with any kind of estate planning or not. But at the very least, that session will help you get more financially organized than you've ever been before. And you will have a full and complete understanding of the law, how I work, how my team works, and what it means. You will know what it is you need to do to protect your families and loved ones at that point, regardless if you hire me as your attorney or not. That's okay. That's my gift to all of you, out of respect to Paul, if you guys ever want that. So reach out to Paul or go to skyunlimited.law to find us and reach out to us and just drop Paul's name and we'll give you that planning session for free. Save $750. Nice.
Oh, thank you, sir. That was really great. That's awesome. It was great having you on the show today, and I look forward to having another show with you based on, further information that we might get and from the inquiries that people might have and stuff like that. So it was really a pleasure having you today on the show, and just like that.
Likewise. Thank you. It's my pleasure as well.
All right. Thank you, sir.